welcome to everybody for this webinar of the British Institute of International and Comparative Law on international criminal responsibility. I'm the moderator of the event, and we've got 3 speakers and 1 speaker who will be doing the closing remarks. I will be very short in introducing the speakers because we have little time, and we are very excited to hear that there's some 400 people who registered for this event. So we are looking very much forward to your participation and to your taking part in the Q&A. So let me first introduce myself. My name is Christine Vanden Weingart. I'm a judge now at the Kosovo Specialist Chambers. I've been a judge at the ICC for 9 years, before that at the ICTY for 7 years, and then before that at the ICJ as an ad hoc judge in the arrest warrant case. Our speakers today are Professor Claus Kress, who is a professor of international law and criminal law at Cologne University, and also a director of the Institute of International Peace and Security Law at that university. Klaus Kress has been a member of Germany's delegation in the negotiations regarding the ICC ever since 1998. He's a judge ad hoc at the ICJ in the case of the Gambia versus Myanmar. Second speaker is Professor Bill Schabas, who is a professor of international law at Middlesex University. He's an emeritus professor at Leiden University and a visiting professor at Sciences Po, the Paris School of International Affairs. Bill has served as one of the 3 international members of the Sierra Leone Truth and Reconciliation Commission, and he's the author of more than 20 books on human rights and international criminal law. Elise Van Sliedricht is a professor of law and director of the Center of Criminal Justice at Leeds University. She was a visiting professional at the International Criminal Court at Chambers, and she also has published extensively in the field of international criminal law, more particularly on the subject of today, because she is the author of 2 major books on individual criminal responsibility in international law. So before giving them the floor, I will proceed to a short introduction. This topic of today, international criminal responsibility before international courts, is a relatively new subject. As we know, the recent history of international criminal justice, if we look at our own lifetimes, starts somewhere with the Pinochet moment in the 1990s, 1999, the International Court for the Former Yugoslavia being up speed, the Statute of the International Criminal Court being approved in 1998. So a lot has happened since then, many years have passed, and a lot of jurisprudence has seen the light, but mainly in the field of the core crimes for which these courts have jurisdiction, that is to say, genocide, crimes against humanity, war crimes. So there the jurisprudence is very rich and is more or less settled, although there's still quite a lot of questions that need to be addressed. But this is in big contrast with the topic that we are discussing today, because if you look at the topic of international criminal responsibility, you will see that even to this day, this is a very hotly debated topic and something that divides judges, scholars, and the academic community. Only very recently, those who have followed the ICC cases, you will see that in the most recent, or the one before most recent judgment of the appeals chamber at the ICC, the judges were bitterly divided. So you had a 3 versus 2 ruling on this subject with Judge Eboe-Osuji and Judge Morrison dissenting on the subject of joint co-perpetuatorship. So how has this come along? The problem with individual criminal responsibility for these type of crimes is that it precisely lies in the nature of the crimes. Genocide, crimes against humanity are not the work of just one person. It's the work of a group of persons with different places in hierarchies. And the main purpose of these international institutions has been to focus on the highest responsible, on those who carry the responsibility as military architects, as political architects, and to apply the typical theories of criminal responsibility to these higher responsible is not without difficulty. And that is why the courts have been struggling with that and have been trying to develop, well, jurisprudence that would fit this type of cases. Let me illustrate it with what is sometimes called the Hitler paradox. To prosecute Adolf Hitler, according to the typical notions of the criminal law of most jurisdictions, commission, aiding and abetting, that would make Hitler rank as a very secondary accused. He would not be guilty of really perpetrating the crime, at least not according to the typical notions of commission that require the presence of the accused on the place where the crime has been committed. And that is why these tribunals, the ICTY and the ICC, have been looking for ways to sort of upgrade the aider and abetter into a committer of the crime, into the most responsible for the genocide, war crime, crime against humanity. And they've done this in quite different ways and divergent ways. And that's precisely what we are now looking at today. So in order to better introduce this, let me show you on the share screen the texts that we are looking at. So I'm first going to show you, let me first try to share my screen and to see whether this technology helps. So here, the first text that we are looking at is, let me see, yes, is the article of the ICTY statute, Article 7.1 on individual criminal responsibility. So here you see a quite classical, I must do something because I can't see my screen here. I have difficulty seeing my screen. So here you see how individual criminal responsibility is defined in one big sentence. So here, unlike what we're going to see in a moment at the ICC, there's a different list of different forms of criminal responsibility. Here it's all in one. And in the charging policy at the ICTY, it was not very much distinguished which of these several subparts of Article 7.1 were charged. But even then, in the very first case, the Tadic case, the court felt a need already to upgrade the notion of commission to something higher. Not pure commission, which would then possibly in the eyes of many require the presence of the accused on the place of the crime, but also the person who was not present. And that was the case with Tadic, because Tadic was was a militiaman heading a group of people who in a village in Bosnia entered the village. Oh, I have been playing too much. Entered the village and committed a number of gruesome acts. And when Tadic had left the place of the crime, his people murdered a number of people, a number of citizens. And this was the reason why the trial chamber has acquitted Tadic, because he was not present at the place of the crime. The appeals chamber, however, Judge Cassese, writing for the chamber, was of the view that this was not right to do, because commission, he said, is to be interpreted in a much broader way as just the presence of the accused and the accused perpetrating the objective element, the actus reus of the crime. It needs to be broader. So he said commission doesn't end there. And that was then the basis for this theory of joint criminal enterprise that is further developed in the judgment, and that we may further look at in the debate. This was very much criticized because according to some, this was going much beyond what the literal interpretation of the statute allowed, was making a quite stretched application of customary international law. And this was one of the reasons why when the ICC statute was adopted, the drafters of the statute went for what they thought was a stricter way of defining the individual criminal responsibility. So here we have now Article 25.3 of the ICC statute, which defines individual criminal responsibility in several paragraphs. So it's not in one paragraph, but in several paragraphs, which has led prosecutors at the court to charge very specific paragraphs of this article, unlike what was often done at the ICTY. So in the first paragraph, we have the notion of committing. In accordance with the statute, a person shall be criminally responsible when he commits such a crime. This is Article 25.3a, whether as an individual, jointly with another person, etc. So this is the basic crime, which according to many who interpret this article is the more serious of the whole list that now follows. Commission is more serious than ordering, soliciting or inducing the crime, or paragraph 25.3c, aiding and abetting the crime, which is the third form. And then there is still a fourth one, which is contained in Article 25.3d. I'm not going to read it to you, but even at the first glance, you will see that this is something which is not something that you would readily recognize from your national criminal codes. It's something that goes a bit beyond, which is based on amongst others, the Convention on Terrorist Bombing. But so here at the ICC, as from the first case in the Lubanga case, the pre-trial chamber, when interpreting this article, adopted a very broad notion of the term commission. And this was based on mainly German doctrine. And the theory is called the control of the crime theory. It's a theory which was supposed to be very different from the joint criminal enterprise theory at the ICTY. And as from the beginning, it was not shared by all the judges. It was developed by the pretrial chamber in Lubanga and Katanga, which was the same pretrial chamber. But already in the first two cases in Lubanga and Katanga, judges were not in agreement with that approach. Judge Fulford was a dissenting judge in Lubanga. I myself wasn't in agreement with my fellow judges in the Katanga case. And even now, 20 years later, we have 20 years into the existence of the court in the Ntaganda case, we have again a split court over this very, very difficult issue. So where do we go from there? And this is now going to be the topic of our discussion. The law here is very fluid after so many years, which of course is problematic, because how does one now define the notion of commission in international criminal law? We have two different approaches, which are very different. And then what does it mean for prosecutors who have to formulate their charges? What does it mean for defense teams who have to respond to the charges? What does it mean for judges? It's all very confusing. Also for national judges who want to look for guidance at international courts, they will find a very divided set of opinions there. So what we have planned for this seminar is to have a discussion that will address these topics from three different perspectives. So we have, of course, the current perspective, but then also future perspectives, which is the second leg of this webinar. And for the future perspectives, what we were thinking of, it was a suggestion that came to my mind when reading this wonderful new book by Darrell Robinson, Extreme Justice, where he says we have to change the way in which we are thinking about international criminal law. But then the question is how? And this is something that I hope we will be able to discuss in this seminar. And everybody is warmly invited to join in to these topics as they are developed. Before we go to the topics, the three speakers will focus on the Ntaganda case, which is the most recent case before the court, the one, as I was mentioning, that was also that divided the judges. Let me give you an idea of the three topics that we have agreed to discuss amongst ourselves, and say at the same time that you are very much invited to join in as we go along with these topics. We have 20 minutes for each topic, which includes the presentations of the speakers and the Q&A of the public. I must say it's my first webinar of this kind, so I will do my very best to incorporate the questions and to see how I can manage this. So the first question is there a need to retain a hierarchy between commission and the other forms of criminal responsibility, aiding and abetting, etc.? And this is, of course, the basic ground for the divergence, because the idea of upgrading aiding and abetting or other forms to commission is precisely because of this feeling that there should be a proper labeling to the crime. And this was not evident. If you look at Nuremberg, for example, there you see that there's this chapter in the judgment where the responsibility of all the accused is explained in a narrative, but without really the specific labeling. So is this something that we should go back to, question mark? The second question is about fragmentation. Fragmentation, meaning that there are different interpretations according to the courts, according to the judges, according to the academics. There's a difference between the international notions and the national laws. Is this something bad? Is this necessarily something bad? Because in the Rome Statute, states are supposed to implement the crimes, but not necessarily the modes of liability. And then the third point will be looking to the future, how to get out of the trenches. So without further ado, I will now give the floor to my fellow speakers and perhaps ask Elise to start with the Ntaganda case.
Thank you very much, Judge Van Weingart. Thank you, Bikkel, for organising this. So just a few reflections really on the Ntaganda case. So he was convicted for war crimes and crimes against humanity. The crimes were mostly committed by others, and these were people under his control. And there were largely, I think, 2 operations in the context of which these crimes happened, and his liability was traced back to him implementing the plan, drawing up the tactics, the military tactics, that is, and through that was a way of imputing those crimes, which were murder, rape, a whole host of different crimes, to him. Indirect co-perpetuation featured as the main theory of liability, and the disagreement, I suppose I will call it, amongst the judges is not so much around his responsibility for the crimes, because I think there was agreement apart from Judge Eboe-Osuji that he was criminally responsible for those crimes, but mainly the theory of liability, so indirect co-perpetuation as such. So as you said already earlier, 2 of the judges did not agree with it, and 1 actually wrote a separate opinion to endorse her agreement with the theory of indirect co-perpetuation. The Peruvian judge made that very clear in her opinion. Is there a hierarchy? Should we adopt this theory, embrace this theory, because it captures the liability of remote principals, those who do not have blood on their hands? They are the most morally responsible, if you like. And that is captured very well in that first concept, or that subparagraph A in Article 25, where there is perpetration, that's criminalized, and these aren't physical perpetrators, direct perpetrators, but remote principals who perpetrate crimes through others. That theory, the control theory, I mean, I can talk about this for hours and I won't, but I'll very briefly reflect on the contention, the different contentious issues. I think on one side you could argue, and this was argued by the judges Morrison and Eboe-Osuji, that this theory is not really part of the text, it's read into it. You don't need it, you can rely on other concepts, for example, in 25.3d, pursuing a common criminal purpose, contributing to an organization pursuing such a purpose. This doesn't mean that there is lesser liability because it happens to happen under D, which is, according to some, accessorial liability, and therefore lesser liability. It doesn't have to be that way because it comes, you know, the role of the person is weighed in the sentencing stage. The other position is embracing this concept of indirect co-perpetuation, this reflection of a control theory, controlling others to commit crimes, using those people as tools. That is very much the theory that captures masterminds. So it's really a concept that fits international criminal justice, that fits these crimes, and where we talk about systemic crime, people who are committing crimes through organized entities, and as such should also be regarded as the most responsible and should be punished, or convicted and punished and sentenced under 25.3a, which is where the liability of masterminds should be placed. So that's a very brief reflection on the case. I personally do not agree with the hierarchy thesis, but I don't want to, I know that Professor Kress also wanted to say something about this. So I will leave it here for the moment, but I'm very happy to come back to it also in the Q&A. I think I've also said too much already. Thanks.
Okay. Klaus, do you want to comment on Intaganda?
Yes, happy to do so. Indeed, as you say, Christine, there is disagreement. It is very obvious from the Tanganda, the judgment, and the appended opinions. But I consider it a helpful disagreement because through the fact that we have three judges elaborating on the issues in quite some detail, Judge Morrison, Judge Eboe-Osuji, and then Judge Ibanez, I think we have all a clearer picture now of the issues and the different avenues. And I believe it is helpful to distinguish between three legal issues that are very closely connected, but still helpful to be analytically distinguished. The first one is whether indirect co-perpetration has a basis or not in the ICC statute, Article 25.3a. The second issue, whether Article 25.3 establishes what I would call a differentiated system, dividing between principal perpetratorship and accessory participation, with a qualitative difference between the two, and with the criterion of control as the distinguishing criterion factor, or whether Article 25.3 can be better read as a monistic system. The term has been used in some of the opinions appended. So a system where there are perhaps distinctions, but any distinctions are not qualitative ones, but rather some by degree, if at all. And then the third legal issue is the one that Elise has already mentioned, the question of a hierarchy of blameworthiness. And it is not the same issue, because you can have a distinction according to blameworthiness even within a monist system. There is no automatic correlation. So I think it's useful to keep those three issues analytically apart. And now the interesting question, first question after Ntaganda, is where do we stand here. It's not that easy if you read the different judgments of the appeals chamber, differently composed chambers, if you follow them closely, and now with these very thoughtful opinions appended. I believe with respect to those three issues in a series, yes, indirect co-perpetration at that moment in time has a basis in the statute. There is a majority still in Ntaganda that has not challenged that, and it has been elaborated in a very detailed manner by Judge Ibanez. The same is probably true with regard to the alternative differentiated and monist system. Here again, I believe that Lubanga has set the trend, and it has not changed in Ntaganda by majority. And again, this differentiated system has now received a very careful and detailed elaboration by Judge Ibanez. More difficult to say, I believe, where we stay is with respect to this question of hierarchy of blameworthiness. Lubanga started quite clearly tending in that direction of a hierarchy. But then we had the appeals chamber in Bemba et al., which is not easy, at least for an outsider, not very easy to read. On the one hand, they recall the crucial sentences of the Lubanga judgment, but then somehow there is a tendency, Judge Eboe-Osuji calls it a move in the right direction, to somehow downplay the idea in Lubanga without explicitly overturning it, because it reads rather as an explanation of what Lubanga has said, that generally speaking and all things being equal, there is a difference. But then the emphasis in Bemba et al. Is yes, but this should not be read as an automaticity of a distinction. And then there is a shift to the sentencing stage. There is a distinction between abstract analysis, concrete analysis, and it seems that there is a drive to put more emphasis on the concrete analysis. And then there is one sentence in Bemba et al. Which seems to challenge Lubanga up front, and this is with respect to instigation and physical perpetration upon instigation, where I think the appeals chamber has even gone so far to say we do not accept any more serious blameworthiness of physical perpetration if this is done on the instigation of another. Now, 3 points as where we can go from there. I think we have basically 3 options. 2 are very clear from the judgment and the dissenting, in that respect, dissenting opinions. One possibility is that the system which is currently still upheld by the majority is preserved, preservation of the acquis, and Judge Ibanez's opinion, I read it to make a contribution to this, to further consolidate the law in that direction. Then we have now 2 powerful opinions, Judge Morrison and Judge Eboe-Osuji, pleading for quite a distinct change of direction, if I read it correctly, in the direction of a monistic system without indirect co-perpetration, and then very interesting, with an alternative, some may say quite surprisingly, returning into the center stage, which is Article 25, paragraph 3d, which is envisaged by both judges, if I understand them correctly, to be the key form of participation when it comes to group responsibility. And of course, this is not a minor case for international criminal justice. In most instances before the ICC, it will be about group criminality. So under this vision for the ICC in the future, Article 25.3d will regain or will acquire great prominence, and you could call this somehow through the back door a return to joint criminal enterprise first and second category, somehow out of a sudden from a place where perhaps not everybody would have expected it. And then there is a third possibility, which is not so much discussed so far, and which I just want to mention for discussion. There is something in between, not just preserving the acquis, because as we shall probably see, there are problems with the acquis, and also not perhaps this radical or distinct change, but something in between. And the components could be as follows. Monistic system, but a monistic system that incorporates indirect co-perpetration. There is no, I would argue, necessary inconsistency between a monistic system and indirect co-perpetration under the ICC statute as litera A is formulated. No overarching control theory. There have been powerful reasons voiced against the control theory with which I, at least to a significant extent, agree. And certainly not a simplistic hierarchy of blameworthiness. A is more serious than B and B more than C, but perhaps a retention of certain nuances, like distinctions between co-perpetration on the one hand and aiding and abetting on the other. So that could be, and of course this would have to be much more refined in the future. This is just a broad avenue that I'm out sketching. These to me seem some of the avenues for future judicial and scholarly conversation. Thank you, Christine.
Thank you, Klaus. Bill.
Well, thank you very much. And thanks also to Bickel for organizing this. And one of the frustrations of the webinar format is that we don't see all the participants, which is always nice. And very much appreciated when it's in a classroom. I know that there are some current and many former students out there in the audience, as well as many dear friends. So hello, everybody. Sorry, I can't acknowledge you all individually. Let me say a few words first about the hierarchy issue. It reminds me of a debate that we had at the International Criminal Tribunal the Yugoslavia Tribunal of modes of hierarchy of crimes. And initially, in the early cases, there were some suggestions from some judges. I think Judge Shahabuddin at one point suggested there was a hierarchy with genocide at the top, then crimes against humanity, and then war crimes. But very quickly, the judges at the Yugoslavia Tribunal said there's no hierarchy. And we'll deal with this at the next stage, because, and it was, you know, there were arguments on both sides, but it made sense to say that we would address this when it came to sentencing people. And we all know that even in domestic, ordinary, general criminal law, that we can have cases where, although objectively one might say that planned and premeditated murder is more serious than manslaughter, we have cases where there are horrible manslaughters and whether there are rather planned murders. So I think quite different aspects of this question. The first one is whether it's in the statute, whether it's in the Rome Statute. And of course, we don't find the words. We don't find the word perpetration. Judge Eboe-Osuji demonstrates this very clearly in his dissenting opinion. Don't even find the language. And it's an example of great judicial creativity, which is, I think, not really supported by the text of the Rome Statute. The second thing is, do we need it? And there again, I think that both judges Morrison and Eboe-Osuji in the Ntaganda appeal, they make a very compelling case that we don't need this distinction. And they explain that historically, this doctrine developed with some national system, particularly the German system. And Judge Ibanez, in her separate opinion, which is favorable to the whole concept, she discusses national models, not all of them, but the ones where there is an issue that perhaps needed correction and where the doctrine of direct and indirect perpetration or co-perpetration is helpful. But again, the dissenting opinions point out that that's peculiar to certain systems, but that you cannot generalize, and that it's not an issue in many legal systems. I think it's unfortunate that and although we have these three marvelous individual opinions, and what that does, of course, is it's like three different lights shining on a problem, and it brings things out in 3 dimensions rather than in 2. But I wish that Judge Ibanez had addressed that a little more directly, the critique that Judge Eboe-Osuji and decision. I was thinking, what about Eichmann? What about the Eichmann case? Those of you who are interested in this, after you read the separate opinions, go and read the Eichmann judgment and how they deal with it. So Judge Ibanez actually does cite the Eichmann judgment at page 269. Where did I thought I had just paragraph 269. The District Court of Jerusalem in the case of Eichmann found that, quote, the extent to which any one of the many criminals were close to or remote from the actual killer of the victim means nothing as far as the measure of his responsibility is concerned. And she goes on, she's citing the judgment, the degree of responsibility as we draw further away from the man who uses the, I think that's quite a wise formulation by the Eichmann court. I remember relying on this when I wrote about participation and complicity in the crime of genocide, because that's what they were addressing. But they don't refer to indirect co-perpetration. They didn't need a theory of indirect co-perpetration. They were working with a domestic legal order that was, I think, very largely derived from common law. That the system then enforced in Palestine and in Israel about criminal participation. On the District Court of Jerusalem, they were applying the common law, essentially, on complicity, and it worked. So my own view is that the case of that's set out by the 2 dissenting judges is very compelling. They're outvoted, but it wouldn't be the first time that dissenting opinions flip at some point. And again, I think that the argument that this is an issue the determination of the sentence and issues of the second question that was asked, and I don't think the colleagues here have confronted it directly, but maybe just because of time. So I hope they'll come back on it a little bit. The fair labeling issue. I don't remember where this term came in when we started using fair labeling, but it's become very fashionable now to talk about fair labeling as if it's some sacred principle of international criminal law or of criminal law or of law generally. Someone should trace it. You can do a trace somehow on Google to find out when that term was used and how it began. I'm not at all convinced that it's a very useful principle either, this principle of fair labeling. I'm very suspicious that it's actually just a kind of a self-justification for legal pedantry, and that we look at terms and we say, well, we have to dispute them, and we write journal articles about them, and judges write dissenting opinions about them, but ultimate or majority decisions, whatever. But it's a lot of pedantry and not finally very helpful. So I think I've probably spoken longer than my turn. I'll stop there. We'll get another round in a few minutes to contribute some more ideas.
Okay.
Thank you.
Well, I have this problem that I can't see the questions. I only have part of them on my screen. So my fellow speakers, maybe you can see them better than I, and maybe you want to tie in with some of them already. Let me start with this last point by Bill, the fair labeling. It also has struck me as something very new. Doesn't it tie in with also something that is now very much en vogue, and that is to speak of the expressionist value of international criminal justice and the way in which judgments and the assessment of responsibility should really reflect the true responsibility. Maybe this is one of the reasons that this is done. But if you do away with the entire hierarchy, I'm not in favor of it, but one of the arguments is that then the discussion moves from the conviction stage to the sentencing stage, because if you don't attach clear degrees of criminal responsibility to the concepts that you use, the labels that you use, that then it becomes even much more potentially arbitrary, because then judges can go all sides. This is one of the arguments that is being used. I don't know what you have, if you have any views on this.
Can I just come
yes.
in on that? First of all, maybe with regard to fair labeling, as I understand it was initially something that was for the accused, so that he or she knew what the conduct was for which he or she was held accountable and then thrown into prison, basically. And it has been sort of mixed with expressive justice. And so fair labeling with regard to victim community, so they know that those who've maybe masterminded crimes behind the scene of the crimes, that they are the ones that are actually the perpetrators, that goes towards fair labeling. But that's a sort of wrong use, I think, of the term initially, at least, or what it was meant to be was really for the defendant and what he or she is charged with. And I think what you could say with regard to the theory of control is that it's actually really complicated to explain to defendants what they're charged with. I mean, try and explain indirect co-perpetuation, I think eyes will glaze over. And I mean, I know when explaining it to students, it's already difficult. Always I have to look at all the requirements, and it's a complex theory. So with regard to that side, I think that's where fair labeling, in its original sense at least, comes in. The expressive value of the theory of control and trying to capture the liability of those who are remote principals, masterminding crimes, I think is welcome. I think it's in the statute, it's in 25(3)(a) with the concept of perpetration through another person, but it's just in A, and the rest of the provision is classic complicity theory. It's just, you know, they've thrown in all the modes of liability to capture any type of wrongdoing or contribution towards wrongdoing, just to be sort of comprehensive, I think, and then leave it up to the judges basically to further refine the system. What has happened with the control theory, unfortunately, is that it has become the sole grounding of Article 25, making B to D the sort of accessorial liability, which is lesser liability. And I think Judge Morrison, in his separate opinion, very clearly made that point when he said that, what about physical perpetration? Why should that be more serious if you adopt the hierarchy theory? Then, I don't know, instigation. So that's why I've always viewed Article 25 as it's A is different types of perpetration, and the rest of it is complicity theory, the sort of modes of liability that you find in many domestic criminal justice systems. But there is that added value to the theory of control of the remote principle, and that's because of the expressive interests, I think, of international criminal justice. But there are definitely other ways of capturing it. But if you look at the travel, if you look at the provision, I think there is no ground, as Bill said, to endorse a theory as Judge Ibanez does. I'm afraid I don't agree with her praise of it in that sense.
And do you agree with the fact that you can read it into the statute? Because that is still another matter. The statute is a very strict interpretation, unlike the ICTY statute, which can rely on customary international law, which is a bit more flexible. But here with Article 22, the strict interpretation leads to quite well stretched notions of committing.
Christine, may I?
Yes, certainly.
May I come in on the fair labeling, and I will say a word on legality as well. With regard to fair labeling and expressionist theories of criminal justice, you have made a connection. I'm certainly very inclined to accept a high value to expressionist theories of criminal justice and international criminal justice. But there is no automatic, so to speak, deduction from an expressionist theory to fair labeling in the sense that it should translate into a hierarchy of blameworthiness under Article 25.3. I think there is a lot of value in somehow articulating where the highest responsibility for a crime lies. And I would suppose that we all agree about the usefulness of making that clear. It already starts when international tribunals concentrate their proceedings on those most responsible. So there is a need to distinguish. But then there is a second question, where do we make that choice? And the basic alternative is, do we establish a hierarchy of blameworthiness already as implicit in the different forms of participation, or do we leave it to the sentencing stage? This is, I think, very much the alternative. At the sentencing stage, in the ICC law, Rule 145 obliges the judges to distinguish, to differentiate according, among other things, the degree of participation. So that's, I think, is undisputed. And I think this is one of those points where we should free ourselves from national tradition and socializations. For a German scholar who is very familiar with Klaus Roxin's theory, there is something familiar and natural to think about the perpetrator as being the main actor. This is the picture that Klaus Roxin has developed. But already, Christine, in German law, which is quite often overlooked, there is a lively debate. Not everybody agrees with Klaus Roxin. It's not that Klaus Roxin is the German scholarship and not even the German jurisprudence in all respects. So there are different views. We have also a lively discussion about the Hitler example that you have. Not everybody agrees in the German distinct that he must be characterized as a perpetrator. And that's even more true. We have to recognize, as Bill said, as Elise said, and as it is written in the opinions, there are many national systems who lay emphasis on drawing those distinctions only at the sentencing stage. So I think we should not be wedded or married to those distinctions. We should look at the ICC statutes text and see whether it makes use to draw certain distinctions already before the sentencing stage on the basis of that text. That's the key question. And I think we cannot simply rely on the tradition of international law, because the ICC statute has made some conscious distinct choices. And we can also not exclusively rely on comparative law, because we have to realize we have quite a variety of different solutions here. So we really have to look for the best arguments when it comes to the ICC statute. And here my view is that simply saying A is more serious than B and then down the road, this is too simplistic. This is not convincing, and Judge Eboe-Osuji has made it very clear when he refers to this example, how to make a distinction between the direct perpetrator who has acted upon the orders of a more remote person. Of course, the person who orders is not necessarily a person with lesser responsibility. However, what about distinguishing, and we are required to distinguish, Article 25 calls us to do so, between co-perpetration, or let's call it co-commission, because Judge Chile doesn't want us to use the term perpetration, co-commission and aiding. I believe we have to come to an interpretation that avoids a complete overlap, which makes those two instances completely interchangeable, and then probably there is something like a more substantial contribution when it comes to co-commission than to aiding and abetting, or aiding at least, where the threshold is a little bit less demanding. And then you have a kind of presumption that co-commission is indeed more serious, all other things equal, than aiding. So this is what I mean by nuances. Perhaps there is not just a simple yes or no, but nuances and distinctions to be worked out.
Can I just very briefly respond?
Mm-hmm.
Very briefly, yes. Because I would agree with that. And I think there is precedent. I mean, if we think about international criminal justice as, you know, a coherent model, when we want to work towards trying to have the jurisprudence of the ICTs and the ICC sort of, you know, aligning, I mean, aiding and abetting has developed into a sort of type of facilitation, a mitigated form of liability. And I think there is definitely, you know, in terms of legality, it would be the right thing, I think, to develop co-perpetuation next to aiding and abetting. It started with Tadic. That's where they literally said.
And the case of Taylor in the Sierra Leone tribunal, aiding and abetting, he got 50 years. So that really shows that this labeling doesn't really mean something in practice.
With Taylor, I agree with the 50 years. I think it's a bit of an outlier, to be honest, because there is research into sentencing, and aiding and abetting generally comes down with lower sentences. And because of the distinction between co-perpetration and aiding and abetting, that is something you can trace in ICL. So I would agree with that. But that's the only hierarchy as far as I'm concerned.
Right.
Yes, before we leave the expressivist fair labeling issue, I like the way Elise described it earlier. She said the mastermind. She did see that's the direct is the mastermind.
Bill, we don't
Elise,
hear you.
And we asked you to explain.
We have difficulties hearing
you. Can you hear me now?
Bill? Yes.
Can you hear me now?
Yeah.
Yes, yeah, but it goes back and forth.
Yeah, I have a problem with my internet. There are too many people watching Netflix in my building, I think, or maybe attending the seminar for all I know.
Bill?
This expressivist issue to say to the victims what Taganda was convicted of. Call him a mastermind, they'll understand that. I think if you tell them that he was found to be an indirect co-perpetrator, they would say, only an indirect co-perpetrator? He's the bastard who was responsible. So I don't think indirect if the whole purpose is fair labeling and expressivism, I don't think indirect co-perpetration does the job.
Yeah,
I would agree.
Also, if you look into the facts as they are explained in the judgment, much of it was ordering, was instigating. So this is something that speaks much more to the imagination of the public in terms of expressivist value, and also labels what happened more adequately. All right. There's perhaps still one question I wanted to ask in this first topic, and that is the control of the crime theory and the nature of the contribution to the plan. Because here there is this distinction between the essential contribution that is required for commission and the significant contribution that is required for Article 25(3)(d) and substantial contribution for aiding and abetting. I often have struggled with the difference between these words and whether this really has a substantive meaning, substantive, significant, essential in practice. Is this something that you wish to reflect on, Elise? You are the great specialist here.
Yeah, I think it just reflects again this hierarchy. So essential contribution, obviously the person who's most important or is without whose contribution the crime would not have been committed. So that shows you that this is really a person at the center of criminal activity rather than a person on the margin who then substantially contributes. But it is difficult. I mean, especially the distinction between significant contribution and a substantial contribution. I think the significant one is for joint criminal enterprise. I wouldn't know how to distinguish the two, to be absolutely honest. I do find the essential contribution an interesting one, and it does work, I think, because of this counterfactual reasoning that if you would not have contributed the whole thing, the whole crime would not have been committed. And that's something that is used also in domestic systems to distinguish between co-perpetration and aiding and abetting in your own system. So I think that one works, but the significant substantial one doesn't. And for me, it's just another reason that the a rigid hierarchy throughout the whole of 25 and then trying to distinguish types of contribution is really not workable.
I'm looking at one of the questions. I'm sorry, Claus, but there's one of the questions that might tie in with this, because if you say essential contribution, then you also think of the notion of causation. And I'm looking now at one of the questions, and I can't read it because I don't get it fully on my screen, but it says the suggestion by some authors to move from causation based to risk-based interpretation of Article 25.3c. For example, by relying on the German theory of Roxin. This is something suggested in the context of neutral acts. And then I can't read it all, but it refers to members of the Saudi-led coalition in Yemen. Maybe my fellow speakers can see what the full text is. Is this something one of you?
Yeah, I saw the question, and my first response, but I will try and keep it short because I'm sure others want to jump in. I think this is a really interesting idea that you move away from cause-based liability and go to risk aggravation, which is a complete different approach, and that's basically what Daryl was doing in his book. That third way that he says, let's move away from what national law says. Let's move away from customary international law, teleological interpretations, but what works? And then he comes with aggravation, risk aggravation. Yes, that can work, and it would be refreshing because of the typical distance we have with perpetrators from the crime. So cause-based doesn't always work. That's exactly the problem. Trying to build that causal link delivers these contested theories of joint criminal enterprise and indirect co-perpetuation. But we're dealing with texts, we're dealing with defendants' principle of legality. We can't just invent new stuff, I think, and that's also my response to Daryl. So it's a good idea, but maybe for a PhD.
All right. Okay, it's time to move to the second topic, which is about fragmentation. This is again something that goes to you first, Elise, because you have written extensively on this. So can you briefly tell us what you think?
Well, in terms of guidance, so domestic courts, obviously, especially those member states to the ICC, have the task to prosecute these crimes, prosecute and adjudicate, and they will look for guidance in international jurisprudence. And the question has come up, I know, in Dutch courts, where to look, because you've got ICTY law with regard to, for example, aiding and abetting, and then you've got the ICC statute, which is different with regard to assistance. And I'm very pleased that they eventually decided just to rely on domestic law, developed over centuries and clear to everyone. So it will come up because I think domestic adjudicators will feel when they deal with international crimes, especially when it is on the basis of universal jurisdiction, that they are enforcing international law, so they have to look for this guidance. But I would say that with regard to modes of liability, and you said it yourself, Christine, in the introduction, complementarity does not require you to stick to the modes of liability in the ICC statute. And you would want to keep, I think, within your own criminal justice system, unity with regard to the criminal law on criminal responsibility, and not have a separate statute on modes of liability. So also from a domestic point of view, from the defendant's point of view, it's good to rely on time-honored national law. International law doesn't require you Complementarity, I already mentioned it. Another indication that international law doesn't require you is, I think, the draft of the Crimes Against Humanity Convention, where the ILC, with regard to the draft and the provision on criminal responsibility, which looks very much like the ICTY provision, broad generic terms, neutral terms, where the ILC has indicated that it's up to national legislators to deal with it, and they can just rely on their own criminal law. Judges will be more familiar with those concepts. So there is no need to transform that, as it were, to have international modes of liability, if you like, at the domestic level. Apart from, and this is one thing that certainly is reflected in the case law of Dutch courts, very specific international concepts like command responsibility. So those concepts, like crime definitions, with an international pedigree, they will be incorporated in domestic law, and will also, in terms of interpretation, the judges will be guided by international law, but aiding and abetting all those concepts are just common criminal law.
But isn't your ILC example showing that there is some disenchantment with the Article 25 approach? Because it's, as you say, closer to the Article 71 approach, ICTY approach. If we look at statutes that were adopted after the Rome Statute, like the Sierra Leone's, which is came very fast, very quick after the Rome Statute, or the statute of the Kosovo specialist chambers, they all go more in the ICTY direction. So isn't this something that should encourage ICC judges to try and go for some kind of harmonized interpretation of the notion?
I would hope so. Initially, the draft Crimes Against Humanity Treaty did have a provision based on 25, basically a copy of 25, and they changed it. Mm-hmm. Another indication why maybe there is some disenchantment, to use that word, is I think the Iraqi High Tribunal dealing with ISIS crimes that is being set up, and currently in the Iraqi parliament, it has a provision which is similar to the ICTY provision. And so I think it makes it easier for domestic judges to apply, I think, and maybe also for judges who eventually then are elevated into international courts to deal with. To me, 25 is a provision where everything's just thrown in. And the control theory, as I just said, I think unnecessarily complicates matters. But I just don't
maybe also potentially extends criminal responsibility, because the contribution is not necessarily to the crime that is being committed, but even the contribution to the plan as such would be sufficient to engage criminal responsibility, which is very broad.
Yeah, I mean, one of the things, I read the judgment again this morning, parts of it, and I just feel that it is indeed, in implementing the plan, he was held accountable in Uganda. In implementing the crime, it was proved that there was mens rea for rape, for murder, and especially with that second operation, which was further removed in time and location. Well, Judge Eboe-Osuji will know much more about this, obviously. But as I understand it, it removed in time and space, and to then say, implementing that common plan or that plan leading to the crimes, you are culpable for rape and you're going to be convicted for rape. Talking about fair labeling, that's problematic.
Mm-hmm. Claus or Bill, do you want to comment on fragmentation?
Bill, do you want to go first, or? Let me, as you like, Bill.
Je vous en prie.
Merci. Merci beaucoup. So I think with regards to our topic, fragmentation at this stage is not such a bad thing. The fact that we have fragmentation simply reflects that we have not yet found the ideal system, the best system. Let us not forget, while duly criticizing certain tendencies about Article 25.3, that the ICTY model was perhaps also not just shining and glorious. It had its problems. We all know this. Joint criminal enterprise in its certain extensions has. So let us be realistic and just accept this is an ongoing intellectual struggle to find the best solution. And I think Ntaganda and the opinions have made a rich contribution. As long as we are at this stage, I believe national jurisdictions are very well advised, and many of them have chosen that path, not to change direction, not to implement any still discussed international solutions, but to apply their systems. And I can tell you from the German experience, where we are gaining experience with the German Code of Crimes, where the national system of individual participation is applied, and not Article 25.3, because just recognize the German system is not Article 25.3, contrary to some misperception. It works. I generally think that what we are discussing here, which I would call the internal delineation of criminal responsibility, so not the external boundaries where participation starts at a minimum, but how we delineate the different forms of criminal responsibility within the ambit of criminality is less important and less dramatic, whether you choose the term indirect co-perpetration or whether, as Judge Morrison and Judge Eboe-Osuji have suggested, you rather tend to use Article 25.3d. This is certainly worth a lot of intellectual energy, but it is not the most dramatic question when it comes to the practical effects. And so I would be very cautious to advise any national legislator to change direction unless those brilliant international judges are still debating among themselves. Let us be a little bit more patient here and continue to see. Ntaganda and the opinions, they have given us, again, a lot of food for thought. There will be new contributions, reflections about it, and let us wait a little bit. Just one sentence, Christine, because I couldn't respond to it before. Your question about essential, substantial, significant, and so on. I entirely agree with the gist of your question and also Elise's point that those are very subtle boundaries. Impossible, I believe, to draw mathematical distinctions. And this is, by the way, why I believe the better system in the end is a monistic system. I do not believe that you can distinguish between co-commission and aiding by a magic control criterion, which tells you one is categorically different from the other. I would agree there is a distinction, but this distinction is one of degree, which comes to be very subtle in certain cases where you can argue eternally whether you still call it co-commission or aiding. So I don't think we can do without such criteria in the abstract, but we have to recognize they are subtle, open to dispute, and they should not be seen as mathematical, categorical lines. And this is one of my main objections against the control theory as one overarching criterion to solve all the issues like a magic basket.
Well, thank you very much, Claus, for your patience with international judges. You know, don't get irritated that even after 20 years we haven't been able to manage. And so I hope the rest of the world will be as patient as you. But in any event, one of the conclusion to this part of the seminar is that the international criminal responsibility as an international rule as such doesn't exist and is very, very varied. So let us now go to the second part, and that is looking at the future. Where do we go from here? I come back to Darrell Robinson's point that we should think differently, start to think differently about the way we think about international criminal law. Is there a way in which we can get out of these trenches between different schools? Are we getting lost in too much detail? Are we expecting too much if we think that a complex narrative that is always the case for each and any case that comes before the court, that such a complex history can be squeezed into a narrative of one of the different variants of Article 25, for example, which now leads the prosecutors to try and indict different forms of culpability under the different paragraphs with different ways in which the narrative then is molded. Is this not something that we should try to avoid? Is there something that we could learn from this? Is perhaps the fact that there's now going to be a new prosecutor with a possible potential new approach to this all something that we could consider and advise? Perhaps this is something for Bill to start with. Very difficult question.
Christine.
Difficult.
Well, yes. I guess the first question is how much energy we need to spend on this, because frankly, we know that the International Criminal Court is going to have how many more trials in the next decade or the next 15 years, or it has a very central role in international justice, but in some ways its role is very small because most international justice is going on elsewhere. So my real concern about this debate is not getting some clarity at the International Criminal Court. I don't see that happen. I think we can see the divergence in the recent judgment of the appeals chamber. I was asked very recently by someone, now and they're telling me my connection is unstable. Do you hear me?
Yes, you're okay.
I was asked very recently, actually, with regard, I think, to Iraq and the initiatives there, whether we could consider indirect co-perpetuation to be customary international law. And I'd say, when you have judges 3-2 in an appeals chamber, it's pretty hard to draw any clear conclusion about what customary international. You don't decide customary international law by a 3-2 vote, that's for sure. So my concern is the trickle down of all of this at the domestic level. In a way, it goes back to fragmentation. You know, we have fragmentation also with regard to the crimes. We have this issue, for example, about the state or organizational policy for crimes against humanity, which is in Article 7(2)(a). And we have the Yugoslavia Tribunal Appeals Chamber saying there's no such thing under customary law. That's fine if you're before the mechanism or if you're before the ICC, you know what the law is. But what if you're before a court in another country or another international criminal tribunal that doesn't have a second paragraph to the definition of crimes against humanity? What then is customary law? The real concern for me, and again, I think that the debate about Ntaganda, as the debate about Eichmann and others, is how to capture the gravity of the people at the top, the mastermind issue. But I have real concerns with the people more at the bottom end, the people who are going to get caught in the international criminal law net, either because their involvement is remote from the crime itself, and we have examples of that, particularly in the refugee environment. People often overlook the fact that there's a lot of international criminal law being applied by refugee tribunals, because the Refugee Convention, Article 1(f)(a), denies refugee status to people who are against whom there are serious grounds to think they've committed an international crime. And so we take with us these definitions also of complicity, and we may have a lot of overreach there. The other thing is, and I think this has always been a problem with this goes back to joint criminal enterprise as well, but with the theories which are to a large extent applied in order to capture the rebels. We can see this, we saw this with Charles Taylor, who was the original indictment against Charles Taylor, had him being part of a joint criminal enterprise to overthrow the government of Sierra Leone. since when is that a joint criminal enterprise? Since, this is what rebels do. And sometimes the rebels are bad people and we don't like them, but sometimes we like them. Think of the African National Congress in South Africa. And I wouldn't want to see overreach of a net of complicity to capture them. I think there's a danger there of overreach. I'll give you a recent example of something going on at the ICC in one of the ongoing cases, the Al Hassan case. It's the second Timbuktu case. And Al Hassan, according to the confirmation hearing judgment, is, amongst other things, being prosecuted for being an accomplice in the war crime of unfair trial, of denying an unfair trial. He's the head of the police. He was the head of the police in Timbuktu. And so he's preparing the reports when people make complaints, and then he goes to judges who deliver unfair trials, and he's accused of being an accomplice. I frankly don't get it. I don't see why he's an accomplice. If I was a citizen of Timbuktu and I was a victim of a crime, I go to the police chief and make a complaint, and I'd expect him before judges. When I can see Al Hassan's just doing his job as a police chief. Now, maybe there's evidence that I don't know about that's going to link him more closely to the unfair trial part of it. But I'm concerned that the complicity notion goes too far. And we see it sometimes in refugee law, and we see it in these situations where we have rebel groups where there's always been a tendency. I don't blame the judges for this. I blame the prosecutor. Complicity with the government, like with Museveni in Uganda. And so they've gone after the rebels and developed very expansive theories of complicity to get them, charging them with, well, I'm talking about the substance now, the joint criminal enterprise theory. But that's a concern for me of overreach, also of the participation dimension of it, that we're applying standards and norms to the rebel groups that we don't apply when it's a non-international armed conflict to the other side. And that creates a lack of symmetry, which I think is harmful to the system, which discredits it and weakens it.
Thank you very much, Bill. I'm looking at the time and we are coming to the end of this webinar. Does any of the speakers want to pick up with the questions that are still here? Because I can't read them. So is there something one of you would want to pick out? Well, if that's not the case, I will now pass the floor to our last speaker, who I don't need to introduce, Judge Chile Eboe-Osuji, who was the former president of the International Criminal Court and my very dear colleague for 6 long years. We've worked together in many trials. So yeah, without further ado, I can perhaps add that but I suppose everybody knows that he was the legal advisor to the United Nations Commissioner for Human Rights. He served as the principal appeals counsel for the prosecution in the Taylor case. We've mentioned it a few times. He taught international criminal law at University of Ottawa, and I don't know, but I have been told that your further path is also in that direction of academia. So let me first wish you all the best in your future career and give you now the floor to wind up this webinar. Judge Eboe-Osuji.
Well, thank you very much, Christine and colleagues. It's always a pleasure being with you. And yes, indeed, I'll be returning to academia. So that is the trajectory. By the beginning of July, I should be on my way over there. This is definitely an interesting discussion. Again, I did flag it. It is important to look again at this question, and I'll tell you in a minute why that is so. First of all, Christine, when you introduced the matter, you might have given the topic recency. But I do think that the subject of criminal responsibility in international criminal law goes all the way back to the Paris Peace Conference of 1919. After all, that was the subject of the work of the Commission number 3, that is, the Commission on the responsibility of the authors of the war and on enforcement of penalties. That is the name itself of that commission suggested. And it came down as a continued life, and of course, nothing came of that, despite the attempt in Article 227 of the Treaty of Versailles to try and indict the Kaiser in the court of, we know that formulation, that the bill is the master of that subject. But in Nuremberg, return to it, again, well, we have in the Nuremberg Charter, the IMT Charter, and the Charter of the International Military Tribunal for the Far East, as well as Control Council Law number 10, all and the same kind of code of, or capturing code of criminal responsibility as you would have in Article 25 of the Rome Statute. In other words, the monist theory. It was not, or the concept of it. It was not a topical issue in Nuremberg or during the Nuremberg era, because it wasn't, it shouldn't happen. If it happened the case, then it would have been interesting to see how the Zyklon B case might have ended. If we remember, that was an instance where the suppliers of Zyklon B was used in the gas chambers of Auschwitz had claimed that they thought they were supplying Zyklon B for the lysing or termination of rodents in the concentration camps. But the court was not persuaded, the British military court was not persuaded, and they said, yes, you are guilty of Mr. Bruno Tasch and his partner of aiding and abetting the extermination that occurred at Auschwitz. And for that, they were punished with death sentence, which was carried out. So it wasn't an issue then. And so the question here is, and that's why was it important to flag this concern at this time? And Professor Kress actually raises that question again. So, okay, after Antaganda, what does all this mean? Well, yes, as I said when I started talking, because I'm returning to academia, and this is not an academic matter. Yes, I do understand the academic ways, but I also have been a practicing lawyer. When you want to do academic discussions, you do that. But when it comes down to a right, we're going to act like courtroom lawyers and judges. We also do that. You don't want to complicate things too much when you're in the mode of a trial lawyer or a judge in the courtroom. You can keep the, harebrained, fine the points of analysis. That's fine for PhD work, and they're their place too. The question here is why this? Here is why. A lot of us here, or all of us here, possibly remember the heartache that occurred in Bampa when the judges suddenly felt, hang on, this theory of appellate deference doesn't work. We know what happened, and judges decided according to their conscience. And if there is something people need to know by now, is that you cannot control the conscience of ICC judges with orthodoxy of theories. Yes, all these fancy theories can work from time to time until at some point down the road, somebody says, sorry, it doesn't work for me. And if you have a majority of judges who what was done before, somebody say, hang on, it doesn't work. And then you have all the chaotic that can resolve for me. That is what this is about. So let's think about this thing. Where is this taking us? All these theories, what is it doing? Are we going to have a scenario where you have Eboe-Osuji and Morrison? Okay, that's 2 out of 5. Now, I'm not sure that we can stretch it to say that the outcome of the intergender was there was a majority that retained the theory of indirect perpetuation. I'm not sure we can say that. It may well be that some judges felt, well, it's not necessary to engage that discussion at this stage, whereas some felt it was important to speak up on it. So the point being, if you have 2 judges saying, hang on, we see difficulty here, it's not difficult to see down the road 3 or more judges in a case saying, sorry, we do not buy the theory that was used to convict somebody, we're going to reverse that. And so let's think about that up front before we get to that point. Now, the point I tried to make, again, I don't want to, what I said quite a bit in my opinion, in intergender, but it truly boils down to this. Are we now, is it a matter of, should I say, ideology, academic or intellectual ideology, or are we asking ourselves, why are we embarked on all these theories? I think that's a question. Why are we doing this? Those who argue one way or the other. Is it really true that there is a gap in the Rome Statute that these theories we're talking about becomes necessary to use to fill? Is it really the case? That is the critical question. Did we have that gap at the ICTR, Nuremberg tribunals, the various ones of them, and in national jurisdictions like common law jurisdictions, France, Italy, these are all jurisdictions that have the monist idea, and the monist idea is something that actually came in common law jurisdictions, became the idea in 1861 when the UK Parliament adopted the Aiders and Abettors Act. So enough of this distinction or hierarchies. We're going to say anybody whose hand is seen in the commission of a crime is going to be treated as a principal. We're not going to make that distinction between principals and accessories. So that is, quite frankly, modernizing position, doing away with the old argument or, again, hierarchies of that. So that is the new approach. Now, if that is the new approach, we see that in the Rome Statute, we see that in France, we see that in Italy, we've seen that in international criminal law. The question then becomes, do we have a gap in the Rome Statute that makes these new theories necessary? That is the question. And yes, I completely agree with Professor Kress, who said there's no inconsistency between indirect co-perpetuation and the monist system. He is correct. The idea of indirect co-perpetuation, you will find even in common law systems, but it's not called indirect co-perpetuation. It is not called anything different from what you see already in the Rome Statute, Article 25(3)(a), that talks about commission through another person. That is where you see your indirect co-perpetuation, commission through another person, but it need not require the concept of control of the crime. It may well be what in common law systems they call producing through endeavor. That's something different and more concrete. For example, a case where two guys were in a bar, and towards the end, one of them tried to play a prank and slipped intoxicant into the drink of his friend, who then drove off. Now, the guy who drank the beer was the driver and was caught by the drink driving legislation. So he was driving drunk. But then somebody said, hang on, somebody slipped. And that is endeavor now, producing through endeavor. The person who put the intoxicant in his drink also committed drink driving indirectly. And that is producing by endeavor. He did something. It's not quite the same thing as constructing any idea and calling it indirect co-perpetuation because somebody feels good doing that. Take, for example, the idea of ordering and instigating. Somebody, a superior orders somebody to do something. It is direct, or do something, commit a crime. It is an order or instigators. Now, if you do that, it is a direct as you can get. Now, are you going to say, well, that superior committed indirectly the crime, when it is quite clear that it was an order that he or she gave? If you're going to characterize it as an order, right, that's what it is. But if you're going to ignore that and want to work through indirect co-perpetuation because you consider that to be the most serious crime, then what becomes of the idea of the order or instigation that was given there? So all these things begin to tell us, let's think again about what we are doing with these theories. So I do not want to belabor the point. Is just, again, the concern is all these theories are all well and good until it isn't anymore. Because in future, a judge says, I am not persuaded that there is a control over the crime. Take again, another one of the things I think about when I think about this control of crime. It is intended, those who support it, it is intended to basically cover the category 1 or 2 of JCE. So, well, let's not go there. Let's do indirect co-perpetuation. But then, if you think about category 1 or 2 in the concept of these sorts of enterprises that will commit crimes, do nasty things, if you start to think about it, from time to time, those people who make up that kind of compact may end up overthrowing the chief through a coup d'etat or an assassination. Now, are you going to say that the subordinate who killed the superior, that the superior actually controlled that crime? So if they can kill their superior, or assassinate the superior, those who did that can also very well commit other crimes against other victims that are not the superior. So all these things begin to ask us the question, is it really true that the superior, quote unquote, controlled somebody else in a manner where they committed the crime? So these are all questions to be debated. I do believe, and I leave it at that the idea is not to toss out Robson's theory. And again, Professor Kress is quite correct to say, well, let's not just toss out everything that is happening at the national system and replace them with theories in international law. He's absolutely correct there. Why do I say that? In Germany, where this theory originated, it had a value. Roxane's theory was a well-intended idea, in my view, as I understand it, at least. But what happened is that it is being taken out of its elements to be applied in a place where we don't need it. When he invented it, came up with the idea, as I understood it, there was a need for it, and one could see that need. If you had a hierarchy of crimes that made distinctions, saying those who perpetrated it as the most serious, others are less accessory responsibility, and he wants to say, sorry, the people you are calling accessories, actually their role is more than that. If you're going to punish accessories mandatorily by way of a lesser punishment, well, that's not correct, he was saying, in my understanding. So what they did deserved the highest level of punishment, and then he came up with theory to get them there. That's fine, but you don't have that difficulty in the Rome Statute. So again, well-intended idea that works well, in my view, that I will support wholeheartedly in the system or in the circumstances in which he invented it. It is just that I don't see that that system is needed here. And I don't know that he will argue that it is needed in the international criminal justice system. So those are food for thought for us to keep thinking. Again, my worry is we don't want to have another Bemba that breaks people's heart down the line. Thank you very much.
Thank you, Judge Eboe-Osuji, for those closing remarks. It is clear that the last is not said about this very interesting, intriguing subject. I hope Claus will be very patient with judges and academics for opinions to materialize and to get more coherent and concrete. So meanwhile, let me thank everybody. Let me thank the speakers in the first place. The judge with the closing arguments, and then all the public who has been with us, whom we could unfortunately not see. So I hope they had an interesting time with us. I'm sorry we couldn't address more questions, but there was so much to say by the speakers that the room for it was unfortunately not big enough. So thank you very much for this, and go home and be well. Bye-bye.